Mr. Ghulam Nawam, you have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you once again on behalf of the State of Israel. This case, even by its very name, the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, suggests an inversion of reality. It has given rise to South Africa's egregious and repeated efforts to bring Israel before this court through the obscene exploitation of the most sacred convention. South Africa presents the court yet again, for the fourth time within the scope of less than 5 months, with a picture that is completely divorced from the facts and circumstances. Israel is engaged in a difficult and tragic armed conflict. South Africa ignores this factual context, which is essential in order to comprehend the situation, and also ignores the applicable legal framework of international humanitarian law. It makes a mockery of the heinous charge of genocide. As Israel has previously stated before this court, when dealing with the law, facts matter. Truth should matter. Words must retain their meaning. Calling something a genocide again and again does not make it genocide. Repeating a lie does not make it true. Here in the Peace Palace, it cannot be otherwise. Mr. President, Israel received notification of this hearing on Monday, less than 4 days ago, while it was observing a particularly painful National Remembrance Day. This notification came as a great surprise, because the court had already invited Israel to submit its observations on South Africa's request in writing by Wednesday of this week. Israel was preparing its written observations when the court suddenly announced that it would hold an oral hearing instead. In seeking to accommodate the court's decision, Israel immediately reached out to its legal team so as to guarantee that it could properly be represented by counsel. That proved impossible, as Israel's lead counsel is shipwrecked this week, and other counsel were likewise unable to come to The Hague on such short notice. For this reason, Israel wrote to the court in good faith, asking that the hearing be rescheduled to next week. It explained that the dates fixed by the court significantly impacted Israel's ability to be sufficiently well represented and the fundamental principle of equality of arms. Israel's request was rejected. The date of this hearing remained that which South Africa had expressly requested. The regrettable result is that Israel is not represented today by its chosen team of counsel and advocates. The equality of the parties and the administration of justice have been severely undermined. Out of respect for this court, the same respect that Israel has shown through all these past several months, Israel's co-agents have nonetheless traveled to appear at this hearing. South Africa's complaint yesterday that Israel has failed to respond to its current request is therefore wholly unfounded. Israel expects that the court will appreciate the predicament that Israel has been placed in. This is all the more so given that South Africa yesterday quite radically changed the terms of its requested provisional measures, which Israel has been given less than 24 hours to respond to. Mr. President, members of the court, bearing all that in mind, allow me to recall 4 basic facts that South Africa continues to conceal. It is highly regrettable, to say the least, that these basic facts must once again be stated in this great hall. First, Israel is engaged in a war it did not want and did not start. It is under attack and fighting to defend itself and its citizens. Since the horrific onslaught that began on 7 October 2023, which saw thousands of Israeli citizens brutally slaughtered, mutilated, raped, and injured, and 254 women, men, and children taken hostage into Gaza, Hamas and other terrorist organizations in Gaza continue to attack Israel, including by indiscriminate rocket fire into Israeli cities and towns. They have vowed to try and repeat the atrocities of 7 October many times over. Since the beginning of the hostilities, more than 10,000 rockets have been fired from the Gaza Strip towards Israel, with the aim of killing as many Israelis as possible. The last 2 weeks alone saw 278 rockets launched. Damage of an unprecedented scale has been caused to Israeli civilian homes and infrastructure, with entire communities destroyed. Approximately 60,000 residents of towns in southern Israel remain displaced from their homes 7 months on. It may be years before they are able to return to their homes and rebuild their communities. Sirens continue to go off across the country as rockets, missiles, and drones are launched against Israel from several fronts. Rafah, in particular, is a focal point for ongoing terrorist activity. It is a stronghold for Hamas's operatives, with several battalions belonging to the Rafah brigades entrenched in the area. Also present in Rafah is an intricate underground tunnel infrastructure that runs underneath the city and provides ample space for operatives, command and control rooms, and military equipment. Nearly 700 tunnel shafts have been identified in Rafah, from which approximately 50 tunnels cross into Egypt. These tunnels are used by Hamas to supply itself with weapons and ammunition. It could potentially be used to smuggle out of Gaza hostages or Hamas senior operatives. Since the start of the present hostilities, more than 1,400 rockets were fired from Rafah alone, including more than 120 in the last 2 weeks. Approximately 600 launch sites were identified in the Rafah area, many of which hidden within or in close proximity to civilian infrastructure. Information regarding rocket launches from Rafah during the current conflict can be found in tab 1 of your judges folder. Israeli hostages are also being held in Rafah by their captors. In fact, Israeli forces managed to rescue 2 Israeli hostages from Rafah on 11 February 2024. I recall that South Africa filed a request with this court the next day for provisional measures that would prevent Israel from taking military action in Rafah, and this request was rightfully denied. South Africa purports to describe Rafah as a last refuge for civilians in Gaza. While many civilians have indeed evacuated to Rafah over the past few months, the fact remains that the city of Rafah also serves as a military stronghold for Hamas, which continues to pose a significant threat to the State of Israel and its citizens. In tab 2 of your folders, you can find a map showing locations of rocket sites, tunnel shafts, and command and control sites embedded in the civilian population in Rafah. South Africa warns this court that, I quote, "If Rafah falls, so too does Gaza." Once again, however, the reality is exactly the opposite. Only by bringing down Hamas's military stronghold in Rafah will Palestinians be liberated from the clenched grip of a murderous terrorist regime, and the road to peace and prosperity may finally be paved. The reality is that any state put in Israel's difficult position would do the same. The right of defense against the brutality of the Hamas terrorist organization cannot be endowed. It is an inherent right afforded to Israel as it is to any state. Israel is committed, as it must be, to realizing this right in accordance with the law, which is why it has worked diligently to enable the protection of civilians, even as Hamas seeks deliberately to endanger them. To deny Israel this basic right would be to suggest, shockingly, that the most fundamental right afforded to all states should be withheld from one. This is an unthinkable outcome that would tell Israeli citizens and the hostages that they are not deserving of protection, of life itself, and tells the Israeli state that it will be treated unequally in a manner that is at odds with the most basic of legal principles. Israel is acutely aware of the large number of civilians that are concentrated in Rafah. It is also acutely aware of Hamas's efforts to use these civilians as a shield. That is why its battalions are present there. That is why its rockets are there. That is why hostages are there. We do not wish harm to these civilians, as Hamas does. That is precisely why Israel is taking steps to try and contend with the massive complexity that such a situation presents. That is why there has not been a large-scale assault on Rafah, but rather specific, limited, and localized operations prefaced with evacuation efforts and support for humanitarian activities. Does Israel face complex operational challenges in Gaza? Certainly. But can we imagine a situation where a state does not take military action to protect its civilians when they are under fire? And can we imagine a court of law telling a state that the law prevents it from defending itself from attack? This is simply untenable. When I last stood at this podium in January, Israeli hostages had been in captivity for almost 100 days. At the time, this seemed inconceivable. Yet the hostages have now been in captivity for over 7 months. More than 130 children, women, and men, including the sick and elderly, have now been held in Gaza for 224 days, incommunicado and in inhumane conditions. Among them is 23-year-old Hirsch Goldberg-Polin. Hirsch was abducted from the Nova Music Festival in Re'im, severely injured. On 25th April 2024, Hamas released a video of Hirsch. In it, he is seen with an amputated arm, which was blown off by Hamas terrorists. He is alive. He needs medical treatment. At least 36 of those who were taken hostage on October 7 have been confirmed dead, and their bodies are still held in the Gaza Strip. Among them are Yossi Sharabi, a 53-year-old father of three, and Itai Svirsky, who is 38-year-old. Both of them were kidnapped from their homes in Be'eri. On 14 January 2024, in a display of pure and unadulterated cruelty, Hamas made public a video of the two and of a third hostage, 26-year-old Noah Argamani, who was also kidnapped from the music festival, promising to announce on the following day which of the three are alive. Shortly thereafter, it was confirmed that Yossi and Itai had both been killed after 102 days in brutal captivity. Additional information regarding hostages still held by Hamas can be found at tab 3 of your Judges folder. It remains unclear how many more innocent victims have been killed at the hands of Hamas. Simply put, this situation is unconscionable. It is unbearable for the parents who watch videos of their young daughters bruised and bleeding paraded before cheering crowds in Gaza, and who have heard harrowing accounts told by survivors released from Gaza of the torture and sexual violence they suffered at the hand of their captors. And it is intolerable for a nation obligated to defend its citizens and wishing for their return. This court has called for the immediate release of the hostages, but to no avail. It is Israel's right and obligation to defend them and all its citizens from the evil that was unleashed on them on 7th October and since then. Any state would do the same. Mr. President, members of the court, I next turn to the second fact that must be kept in mind. Hamas, with whom Israel is engaging in this armed conflict, is not a party to these proceedings. Israel is engaged in an intense armed conflict with a ruthless jihadist terrorist organization, one that is not only targeting Israeli civilians, but is also using Palestinian civilians to shield itself, in utter disregard for their lives or for the law. By exploiting the Genocide Convention, South Africa is suggesting a convoluted reading of international law, under which any armed conflict could be brought before the court. It seeks, once again, to obtain provisional measures that would bind only Israel and not its adversary. The absurd result would be that Israel would be denied its inherent right to defend itself. Hamas, for its part, would remain free to continue committing its horrific crimes. The purpose of the Genocide Convention is not to have the court supervise the conduct of armed hostilities by parties to the conflict, by the assertion of the genocide. Rather, the Convention, and subsequently this court's jurisdiction, is limited to the grave crime of genocide. I am compelled to restate once again that there is a tragic war going on, but there is no genocide. Yet, particularly at the provisional measure stage, when the evidentiary threshold is such that the applicant is not required to provide proof of its allegations or the existence of specific intent to commit genocide, there is a danger that the court will find itself engaged in the micromanagement of operational aspects of an armed conflict. This is what South Africa has been asking the court to do. Judge ad hoc Barak warned precisely of this danger when the court handed out its decision on South Africa's third request for provisional measures. He observed that, I quote, "The court has accepted South Africa's invitation to become the micromanager of an armed conflict and used the Genocide Convention as an excuse to rule on the basis of international humanitarian law. managing an armed conflict under the Genocide Convention is a dangerous endeavor, especially when one of the belligerents is not a party to the convention. This remains true when considering South Africa's fourth request. Mr. President, members of the court, this brings me to third basic fact that must not be ignored. South Africa purports to come before you, yet again, as a guardian of humanity. In fact, it has a clear ulterior motive when it asks you to order Israel to stay away from Rafah and to withdraw all its troops from Gaza. It does so in order to obtain military advantage for its ally, Hamas, which it does not wish to see defeated. It is this reason that South Africa continues to abuse the Genocide Convention, this court, and the procedure of provisional measures. Just 6 days ago, on 11 May 2024, only a day after it submitted the present request for additional provisional measures, South Africa hosted a Hamas delegation in Johannesburg. South Africa's foreign minister herself met with Hamas representatives. They did not use the meeting to urge Hamas to release the hostages, to stop targeting Israeli civilians, to cease using human shields, to cease operating from within and nearby hospitals, UN facilities, and other protected sites. They apparently met to discuss their continued campaign against Israel in the court and on the ground. Mr. President, members of the court, South Africa is not interested in the truth, nor is it interested in law or justice. Once again, it is exploiting the court and its authority to issue provisional measures. It is in no rush to reach the merits of this case when it will have to substantiate its baseless claims with evidence that simply does not exist. Israel, for its part, has shown nothing but respect for the judicial process and for the law more generally. As the court will recall, on 28 April 2024, Israel provided the court with a lengthy report detailing, inter alia, the numerous steps that Israel had actively and effectively taken to address the humanitarian situation in the Gaza Strip, consistent with the court's previous orders. Rather than first responding to Israel's report, South Africa rushed to submit yet another request for provisional measures, its fourth, for fear that Hamas's last significant stronghold will fall. Hamas itself has repeatedly rejected every offer for a ceasefire. On 25 April 2024, 18 states called upon Hamas to release immediately the hostages still being held in Gaza. They said, and I quote, "We emphasize that the deal on the table to release the hostages would bring an immediate and prolonged ceasefire in Gaza that would facilitate a surge of additional necessary humanitarian assistance to be delivered throughout Gaza and lead to the credible end of hostilities." 4 days ago, on 13 May 2024, the United States National Security Advisor noted in the same vein that, and I quote, "There could be a ceasefire tomorrow if Hamas simply released women, wounded, and elderly hostages." Israel put a forward-leaning proposal on the table. The world should be calling on Hamas to come back to the table and accept a deal. South Africa spoke yesterday about rebuilding a viable Palestinian society. Yet, South Africa's actions speak louder than its words. By its actions, it is clear that South Africa wishes to see Hamas remain in control of the Palestinians in Gaza and to destine them to misery. It is Israel that wishes to see a different future to Gaza, one in which Palestinians and Israelis can both live in peace. Hamas, the genocidal terrorist organization, will stop at nothing to prevent that. Mr. President, members of the court, this brings me to the fourth fact that the court must not lose sight of. As is the case with all armed conflicts, incidents involving alleged violations of the rules regulating the conduct of hostilities may occur. This reality is not unique to Israel. No state is infallible. Israel's independent and robust legal system addresses all allegations of misconduct, including in the current hostilities. They must not be thrown before this court in the form of facts and conclusions, and as evidence of something they are not. Armed conflict is not a synonym for genocide. South Africa mentions some individual incidents reported in the media and attempts to present them as evidence of unlawful policies. Yet, exceptional incidents are just that, exceptional. They do not evidence a policy of illegal behavior, let alone a policy of genocide. And then also cannot be cited as fact until a proper examination is carried out. Not every media report reflects facts or incidents correctly or in their full context. Israel has been and remains committed to acting in accordance with its international legal obligations, including those under international humanitarian law and the Genocide Convention. Israel has in place the necessary mechanisms to examine and investigate allegations of wrongdoing by its military forces and to ensure accountability for violations of the law. Information about these mechanisms and their activities since the commencement of hostilities has been provided by Israel in both the report of 26 February 2024 and the report of 28 April 2024. It bears repeating before the court today that since the beginning of the hostilities, 55 criminal investigations have been opened by the military advocate general with respect to incidents that raise prima facie reasonable suspicion of criminal misconduct. In addition, the fact-finding and assessment mechanism, a permanent, independent, and professional mechanism in charge of examining exceptional incidents, is in the process of addressing hundreds of incidents from the current conflict. With respect to various public statements, as I stressed in January before the court, the Israeli legal system knows how to draw a line between statements that are troubling and even obscene, but still fall within the right of freedom of speech in a democratic society, and those statements which go beyond that right. Israel's reports have also outlined the steps taken by Israel's law enforcement agencies to examine dozens of statements made in the context of the current hostilities in order to ascertain whether legal steps are warranted. It was recently decided that some cases justify the promotion of criminal proceedings. At the same time, since the outset of these proceedings, South Africa has consistently cherry-picked statements or taken others out of context in an attempt to attribute to Israel the intent to commit genocide, taking advantage of the low evidentiary threshold at the provisional measure stage. It does so in the present request as well, attributing to Israel alleged genocidal aims and acts based on statements clearly calling for victory over Hamas and for its destruction. Israel has made repeatedly clear that the policy and instructions for conducting the hostilities stem from the decisions of the Ministerial Committee on National Security Affairs and the War Cabinet, and not from various social media accounts or interviews. As Ms. Kaplan-Turgeman will explain, the decision of the Israeli cabinet and their implementation on the ground leave no doubt that South Africa's allegations regarding genocide are completely and utterly baseless. Israel's law enforcement authorities also act to counter Israeli protesters who blocked the transfer of aid from Israel to Gaza. The Israeli police secures coordinated convoys during their passage in Israel. With respect to the incident of May 13, during which protesters caused damage to aid trucks, the Israeli police is prioritizing the investigation, which was assigned to a special investigation unit. It has already resulted in the investigation of several suspects and witnesses. The authorities are acting in this regard and will continue to act in order to investigate and prosecute, if appropriate, and to ensure the continued effective and efficient transfer of humanitarian aid. As part of a lessons learned process, an improved mechanism was adopted by the police and the IDF to ensure the safety of the convoys. Finally, even during hostilities, the door of Israel's High Court of Justice, a central pillar of Israel's robust and independent legal system, are open to those who seek to challenge the actions of Israel's government. This includes non-governmental organizations, NGOs, and individuals who are not Israeli citizens and residents, if they are potentially affected by such actions. In fact, Israel's High Court of Justice is currently reviewing a petition submitted by a number of Israeli NGOs concerning the humanitarian situation in the Gaza Strip. The court is reviewing the compliance of the Israeli government's policy with both international humanitarian law and Israeli law. In its response to the petition, the state has submitted extensive briefs and has participated in 2 public oral hearings before a senior 3-judge panel. It has presented in detail the effort it is undertaking to alleviate the humanitarian situation. An additional statement will be submitted to the court within the next few days concerning, inter alia, the operation in Rafah. As I stated before this court in January 2024, even when the cannons were in Gaza, the law is not silent. Israel's legal system and its domestic mechanisms are a testament to this. Mr. President, members of the court, let me now say something about the weakness of South Africa's allegations. Its counsel berated Israel yesterday for casting aspersions at what it called credible information provided by South Africa. But the sad truth is that South Africa cites hateful social media accounts and unsubstantiated news reports in support of its claims. Surely this cannot pass. An additional flaw in this regard is South Africa's heavy reliance on documents prepared by third parties or under the auspices of the United Nations, when these cannot be said to constitute sufficient evidence of a reliable quality. Indeed, the court has itself had occasion to observe that UN reports may only be of such quality, I quote, to the extent that they are of probative value and are corroborated, if necessary, by other credible sources. The court moreover stated that, and I quote, the precise evidentiary value accorded to any report, including those produced by United Nations entities, also depends on the methodology and the amount of research underlying its preparation. It is important to clarify. Israel does not underestimate the reports of the UN and other sources. We study them, draw conclusions and lessons in the appropriate cases. However, Statements from such reports should not be accepted automatically, especially in a complex combat reality. These words of caution are of particular significance in the present case, as the materials cited by South Africa have been prepared without access to relevant and necessary information, including that held by Israel, and often without any attempt to access such information. They frequently rely on Hamas sources or on those subject to Hamas intimidation. One striking example, which gives serious cause for alarm, is that even UN OCHA, which has so far parroted information generated by Hamas-run agencies in Gaza regarding fatalities, has recently started to accept that the information coming out of Gaza is flawed. It highlighted that more than 10,000 of the fatalities declared by Hamas are unnamed and thus unverifiable. Concurrently, it revised dramatically the number of verifiable fatalities of women and children fatalities to approximately half than was previously presented, and stop parroting the baseless claim that 70% of the casualties are women and children. It turns out that the data that the UN were using and that South Africa has presented to this court as true was wrong. While the number of overall fatalities has not changed, the breakdown is crucial. Hamas has been concealing the number of militants in its unverified lists of Palestinian casualties. Hamas's lists also contain persons who died from reasons unrelated to IDF actions, such as fire of terrorist organizations, and show many irregularities in reported age, gender, and ID numbers. In this way, an armed conflict can easily be portrayed as genocide. As we have stated, every civilian death is a tragedy. Moreover, overall fatality counts during a war are not, in and of themselves, evidence of unlawful conduct under international law. Once again, the facts matter. South Africa has not missed an opportunity to make outlandish accusations against Israel, and its fourth request for provisional measures is replete with blatant distortions and misrepresentations. We heard plenty such outrageous distortions and misrepresentations yesterday as well. Perhaps most repugnant is South Africa's suggestion that Israel has created zones of extermination, evoking terminology reminiscent of the systematic extermination of European Jews during the Holocaust. Similarly outrageous is South Africa's cynical attempt to equate Israel's action with the genocidal practices at Srebrenica. How low South Africa has stooped. These allegations leveled at Israel are patently untrue and emphatically denied. Like many of the claims in South Africa's application and requests, they lack any basis in fact or law. South Africa claims that Israel has closed critical border crossings into Gaza, when this is blatantly untrue. It has claimed that Israel has failed to facilitate the provision of fuel for sustaining humanitarian operations and facilities. This is also untrue. Ms. Kaplan-Turgeman will further elaborate on these points in a moment, as well as on the continuous efforts that Israel has been making to alleviate the humanitarian situation in the Gaza Strip. As Counsel for Israel noted before the court during the oral hearing on 12 January 2024, a state intent on committing genocide would not undertake the operational and the humanitarian efforts that Israel has taken and is taking to mitigate civilian harm. It would not have delayed a ground maneuver for weeks, urging civilians to seek safer space and, in doing so, sacrifice operational advantage. It would not invest massive resources in facilitating humanitarian aid. If anybody should be told that enough is enough, it is truly South Africa and not Israel. At what point do we say enough to South Africa's repeated attempts to exploit the provisional measure procedure of this court in such a vile and cynical manner? This war, like all wars, is tragic and terrible for Israelis and Palestinians, and it has exacted a terrible human price. But it is not genocide. I can only recall once again that Israel has made it clear that if the hostages were released and Hamas were to lay down its arms, the hostilities would cease, and has been engaged intensively in negotiations to that effect. Mr. President, members of the court, South Africa asked this court to order Israel, and I quote, cease its military operations in the Gaza Strip. South Africa has asked the court to order the cessation of military operations by Israel in its previous request. The court has not done so. The court is well aware that to do so would mean that 132 hostages would remain to languish in Hamas's tunnels forsaken. It would mean that Hamas would be left unhindered and free to continue its attacks against Israeli territory and Israeli civilians, which it has a stated intention to do. It would turn the Genocide Convention into a sword rather than a shield, and would strip Israel of its rights under international law and the Israeli civilians of its protection. Such a situation is both legally and morally untenable. For all of the reasons given in response to South Africa's earlier requests for similar provisional measures, the court rightfully rejected South Africa's previous request, and it would be wholly inappropriate to grant a provisional measure in such terms. The second of the provisional measures requested by South Africa repeats earlier requests it has made, either sufficiently covered by the various provisional measures ordered by the court or rejected in previous rounds. South Africa has not given sufficient reason why the court should now deviate from or essentially duplicate its earlier decisions. The third provisional measure requested by South Africa would require that Israel submit an open report to the court on all measures taken to give effect to these and previous provisional measures. As I have said, Israel has engaged fully and sincerely in these proceedings, despite the outrageous and libelous claims that have been leveled against it. It has submitted to the court 2 detailed reports that has been forthcoming about the efforts it is undertaking, as well as the challenges it is dealing with to alleviate the humanitarian situation in Gaza. It has made clear time and again its unwavering commitment to its obligations under international law. It has done this while the fighting continues and the citizens are still under attack. South Africa has responded with a barrage of requests. It has clearly adopted a strategy of dragging Israel to court endlessly, regardless of any legal undertakings by Israel. In these circumstances, ordering Israel to submit another report is unwarranted. Mr. President, that concludes my statement. I ask that you now invite Ms. Kaplan-Turgeman to the podium.